You know, after 43 years on this bench, I've seen greed wear every mask imaginable: the quiet, calculating kind, the loud, entitled kind, the kind that dresses itself up as justice or family loyalty. But on that humid July afternoon in Atlanta, a 42-year-old son walked into my courtroom to sue his own 71-year-old mother for $500,000 in life insurance proceeds that rightfully belonged to her after his father's death. What he didn't expect, what none of us expected, was that in trying to take everything, he would expose a lie so shocking, so cold-blooded, that when the truth finally landed, he was left utterly speechless, staring at the floor while his mother sat there with quiet dignity and tears she refused to let fall in front of him. This wasn't just about money. This was about a son who had already received more than his share in life: college paid for, wedding funded, down payment on his first house, now coming after the only financial security his widowed mother had left. The policy had been in place for 38 years, premiums paid from joint savings, beneficiary designation clear, surviving spouse first, then children equally. But the son claimed his father had verbally promised him the full $500,000 payout to start a business just weeks before dying of a sudden heart attack. The mother said it never happened, and when I peeled back the layers, document by document, lie by lie, the courtroom didn't just witness a verdict, it witnessed a son's mask shatter in real time. Before I walk you through every devastating moment of that hearing, hit that subscribe button right now. Seriously, click it. Because stories like this remind us that blood doesn't always mean loyalty, and truth has a way of cutting through even the thickest entitlement. Drop a comment telling me, have you ever seen a child turn against a parent over money? You're going to want to stay glued to this one. I've been a Superior Court judge in Fulton County, Georgia since 1982. That's 43 years of watching families fracture over estates, wills, insurance, and the endless ways people justify taking more than their share. Every morning I get to court by 7:15, pour my coffee, black, no cream, the way my late husband drank it during his 32 years on the force, and sit quietly for 10 minutes to prepare my heart for whatever walks through those doors. My clerk, Jamal, who's been with me for 21 years, can tell from my face when a case is going to leave scars. That July morning, he handed me the file with a sigh. Judge, son suing mom over life insurance, $500K. He's got a lawyer, she's pro se, and she looks defeated. The file was straightforward on paper. Plaintiff, Brandon Whitaker, 42, real estate agent. Defendant, Evelyn Whitaker, 71, retired school teacher. Subject, declaratory judgment to enforce an alleged oral inter vivos gift of $500,000 life insurance proceeds from deceased father-husband Robert Whitaker, who passed 6 months earlier. Brandon claimed Robert told him privately, "Son, when I'm gone, that policy money is yours. Use it to build something big." No witnesses, no writing. Evelyn insisted the policy was always for her security as surviving spouse. Robert never mentioned changing anything. Brandon was demanding immediate payout to him alone. Evelyn was countersuing for declaratory relief that the funds were hers. The courtroom was tense, family friends on Evelyn's side, Brandon's business associates on his, a few curious spectators. At 1:50 p.m., Jamal called it Whitaker vs. Whitaker, Case 25 CV 3921, petition for declaratory judgment and counterclaim. Brandon strode in wearing a sharp navy suit, confident, almost smug. Evelyn entered quietly behind him, simple gray dress, hair neatly pinned, walker she hated using but needed after a hip replacement last year. She sat at the pro se table, hands folded, eyes down. I started neutral. "Mr. Whitaker, you're seeking a declaration that your father orally gifted you the entire $500,000 life insurance benefit. Explain your claim." He leaned forward, voice smooth. "Your Honor, Dad and I were close. Golf every Saturday, business talks. 6 weeks before the heart attack, we were on the back porch. He said, 'Brandon, you've always had the drive. When I'm gone, take that policy money, $500,000, and start the real estate firm you've dreamed about. Don't split it. It's for you to build something lasting.'" Mom was inside cooking. She didn't hear, but he meant it. Evelyn looked up then, eyes glistening but voice steady. "That never happened, Your Honor. Robert and I discussed the policy every year when we paid the premium. He always said, 'Maggie, this is for you. If I go first, you'll need it to live.' He never mentioned giving it to Brandon alone." I turned to Brandon. "Any witnesses to this conversation?" He shook his head. "It was private, father-son. But he told me multiple times over the years he wanted me to have the means to succeed." Jamal handed me the insurance documents. Beneficiary designation. Evelyn Whitaker, primary, Brandon Whitaker, and sister Lauren Whitaker, contingent equal shares. No change forms ever filed. I asked Evelyn, Mrs. Whitaker, did your husband ever express changing the beneficiary? She shook her head. Never. He updated it once in 2015 after Lauren's divorce. Made sure both kids were contingent. But primary was always me. He said, I want you taken care of first, Maggie. The kids are grown. Brandon interrupted. He changed his mind at the end. People do that when they see their legacy. I sustained Evelyn's quiet objection to the interruption. Then I asked the question that started the unraveling. Mr. Whitaker, you say this promise was made 6 weeks before his death. Can you tell me the exact date? He paused. Early May, around May 8th or 9th. I pulled up the death certificate on the screen. Robert Whitaker died May 22nd. So roughly 2 weeks before? Brandon nodded. Yes. Then I asked Evelyn, where was your husband on May 8th through May 10th? She answered softly. In the hospital, Your Honor. Triple bypass surgery on May 7th. He was in ICU until May 12th. Sedated most of the time. I never left his side. Brandon visited twice, once with his wife, once alone, but Robert was barely conscious. The courtroom shifted. Brandon's face tightened. I looked at him. Mr. Whitaker, if your father was in ICU, sedated on heavy pain medication and not speaking clearly for days after surgery, how could he have had a detailed conversation with you on the back porch about a $500,000 gift? Brandon stammered. Maybe it was earlier. I might have the date wrong. I pressed gently but firmly. You said 6 weeks before the heart attack. The heart attack was what killed him. May 22nd, 6 weeks before is early April. Were you on the back porch in early April? He hesitated. I think so. I had Jamal pull up Brandon's own social media exhibit, submitted by Evelyn's friend who helped her prepare. A Facebook post from Brandon dated April 15th, just closed on a beach condo in Destin, family vacay booked for July, living the dream, tagged location, Destin, Florida, time-stamped photos of him on white sand, drink in hand. I displayed it on the screen. Mr. Whitaker, this post shows you in Florida from April 12th through April 20th. You posted daily. How could you have been on your parents' back porch in Atlanta during that time having this life-changing conversation? Brandon's mouth opened, closed, no sound. The gallery murmured. Evelyn looked down, tears falling silently onto her hands. I continued. And one more thing. Your father's medical records, subpoenaed, show he was diagnosed with early dementia symptoms in January of that year. His neurologist noted short-term memory issues, confusion. Even if he had said something about the policy, was he competent to make a binding inter vivos gift of $500,000? Brandon stared at the screen, then at his mother, then at the floor, speechless, completely. Let me stop right here was because this moment was electric. Have you ever watched someone's entire story collapse under the weight of their own contradictions? Drop a comment right now and tell me, what would you have felt if you were Evelyn watching your son's lie unravel? And if this is hitting you hard, hit that like button because the verdict that followed was as inevitable as it was heartbreaking. I looked at Brandon. Sir, the law requires clear and convincing evidence for an oral gift of this magnitude, especially real property or large sums. There is no writing, no change of beneficiary form, no disinterested witnesses. What we do have is a beneficiary designation that remained unchanged for 38 years, premiums paid jointly, and your father's consistent statements to your mother that she was first priority. I turned to Evelyn. Mrs. Whitaker, I'm sorry you had to endure this. You've already lost your husband. You shouldn't have to fight your son for the security he promised to protect. Then the ruling. The petition for declaratory judgment is denied. The $500,000 life insurance proceeds are awarded to Evelyn Whitaker as primary beneficiary. No constructive trust or equitable claim is established in favor of Brandon Whitaker. The counterclaim is granted. Furthermore, I am referring this matter to the county bar for review of potential frivolous litigation sanctions against plaintiff's counsel, and I am ordering plaintiff to pay defendants reasonable attorney fees, which she incurred despite being pro se, in the amount of $12,400 as documented. I didn't raise my voice. I didn't need to. Brandon sat frozen. Evelyn let out a small, choked sob, not of victory, but of relief mixed with grief. The gallery was silent. No applause, just a collective exhale. As Evelyn stood to leave, Brandon finally spoke, voice barely above a whisper. Mom, I'm sorry. She looked at him, tears streaming. I know you are now, Brandon, but sorry doesn't bring your father back, and it doesn't undo what you tried to do. She walked out with her walker, head high, neighbors surrounding her like a quiet guard. 3 months later, Evelyn wrote me a letter. Judge, I never wanted to sue my boy, but I had to protect what Robert left me. He started calling again. We're talking. Slowly. The money helps, but the truth helped more. Thank you for seeing through the story to the heart. Brandon paid the fees. No appeal. Word is he's in counseling. Sometimes the most shocking lie exposed isn't the one told. It's the one someone tells themselves until the courtroom forces them to face it. Stories like this carve deep lines. Greed can blind even a son to his mother's pain, but truth, quiet, relentless truth, can sometimes open eyes before it's too late. If this shook you, if you believe family should never come with a price tag, hit that like button, subscribe for more raw courtroom revelations, and share this with anyone who's ever felt taken advantage of by their own blood. Comment below, would you have sued your child to protect your future or walked away? Thank you for listening. God bless. Justice doesn't always feel good, but it always feels right when the mask finally falls. Check the next video. Another inheritance battle with an even bigger twist is waiting. Take care of the ones who took care of you. They won't always be here to fight for themselves.